All right, so without any delay, now let's proceed towards our second session, which is a discussion on decoding the Digital Personal Data Protection Act 2023. You heard Mr. Avinash Gupta talk about it briefly, so let's dive into this session right away. The discussion will focus on the impact of Digital Personal Data Protection Act on personal and professional aspects, the obligations to be managed by corporate entities, and much more. So, ladies and gentlemen, let me introduce to you our eminent panelists who we have today. And as I call upon your names, I would request you to please come on stage and join us here. First up, we have Mr. Satya Pattanayak, Practice Lead, Enterprise Cloud and Data Architecture, Specialist Product Manager, Group Data and Analytics Cell, Aditya Birla Group. Please, sir. Can we have a huge round of applause? Next on the panel, we have Mr. Arun Sadhanand Prabhu, Partner, Head, Technology and Telecommunications, Cyril, Amarchand, Mangaldas. A round of applause, ladies and gentlemen. We also have with us Mr. Jaideep Reddy, Partner, Technology Law, Trilegal. Please, sir. Next up, we have with us Mr. Thomas George, Chief Data Officer, Societe Generale. And to moderate this discussion, we have someone equally eminent. Sorry, did I miss someone here? Also joining us would be Mr. Satish Kumar Dwibhashi, Chief Information Security Officer of Kreditbee. A big round of applause for Mr. Dwibhashi. And finally, we have an equally eminent moderator with us today. We have Mr. Akhil George, tech journalist for the Times of India. Ladies and gentlemen, a big round of applause for this entire panel. Over to you, Mr. George.
Akhil George and Thomas George sits together.
I'm sure they did it on purpose. So thanks everyone. Thanks for being here. So why don't we just kick it off? Jaideep, why don't we, I can't see anyone, sorry. Hi Jaideep, so why don't we start with you? DP, Digital Personal Data Protection Act. First of all, it's a mouthful. Can you help us, maybe give us a little bit of a history on it? How has it evolved over the years? From what we understand, it's a law that took 10 years to make. So why don't you start off?
Sure. Thank you for having me. It's, as you said, it's been a journey to come to where we are. We for the longest time had a set of rules under the Information Technology Act. Those rules came in 2011. But the journey really started with the Supreme Court back in the 60s and 70s setting out some contours of a fundamental right to privacy. There was no statutory codified law or anything in the shape of a data protection law for a long time. Then with the advent of the internet, the law called the Information Technology Act came in. Even then, for 11 years, there was no specific privacy law except a few sections, very bare-bones sections. In 2011, some basic rules came in, which in fact are still the law today, which is the Reasonable Security Practices and Procedures rules. Those rules basically mandate something called a notice and consent regime, where essentially, as you would see from your online user experience, you go on a website, you say, I agree to a privacy policy. The privacy policy says what data it collects about you and how that data is used. There are some guardrails around it, but overall quite basic and not very prescriptive. As more data usage evolved, as data flows evolved, the volume of this activity evolved. Conversation started about how citizens' data can be better protected through a dedicated legislation. And that issue hit the peak of the public conversation possibly when the Aadhaar case came out. That as the government was developing the Aadhaar system, a few people filed public interest litigations, including a retired judge by the name K.S. Puttaswamy, that the Aadhaar system may violate the people's privacy rights because it creates a consolidated picture of the individual, which could create a surveillance state by the state knowing everything about the individual. In that context, that matter got referred to 9 judges of the Supreme Court, and the Supreme Court was called to say that whether citizens have a fundamental right of privacy or not under the Constitution, because there was some ambiguity around that as to whether that right existed. And in 2017, that pronouncement came by a unanimous verdict that there is a fundamental right to privacy under the Constitution, even though it's not expressly mentioned. After that, there have been judgments enforcing that right to privacy in some contexts. But in that matter, the central government said that we are developing our privacy law. It is not yet in place. We are coming up with a draft. So where that led to is in 2018, a committee was constituted led by Justice Sri Krishna, which put out a consultation paper on what our potential privacy law could look like. Responses were sought from all over the country. The committee published a report after hearing those responses again. And finally, in 2019, a data protection bill was introduced in the parliament. That was a quite prescriptive bill with various detailed protections and arguably from an industry perspective somewhat onerous. So there was likely some pushback against that, and therefore that bill did not pass. Meanwhile, we had COVID and other pressing exigencies. That the bill got referred to a joint parliamentary committee. Finally, towards the end of last year, another version of the law was released for public comments. And finally, we are where we are today, where in the last session, the law was introduced and passed. And where we stand today is that the law is on the statute book, but has not been notified to come into force. So we need the central government to pass a notification as to when this law will come into force. There are also rules and regulations awaited under this law as to how some of the detailed compliance requirements will flow. But that's basically broadly how we got to where we are today.
Please. Take that.
If I can just elaborate a little bit on something Jaideep said. This history gives us a couple of very interesting points which are relevant in terms of how this law will pan out, right? Number one, they took a law which was about 60 odd pages, very comparable to the GDPR, global standard, etc., and they withdrew it. Unheard of, right? Joint Parliamentary Committee had sat on it, it had been circulated for 2 years, PP Chaudhary was on that Joint Parliamentary Committee, they still withdrew it. And one of the primary reasons they withdrew it is because it was too elaborate and too complex. This law is 19 pages, including 18 pages actually, including annexures. One of the shortest pieces of data protection legislation anywhere in the world. And we feel this trend will continue into the rules. So if anyone in the audience is looking for the rules to come and to get like extensive guidance about how the law will work, that's not going to happen. It's going to be a crisp, crunchy set of rules. I think the second thing that was, we can again take away from this sort of trend is, and Jaideep made the point about how this is an expression of a Supreme Court order, right? So Puttaswamy lays down the principles of privacy which are going to govern all of us. So this law won't operate in a vacuum. Just because it's a brief law which contains very, brief language, there's already a tendency in the market to say, oh, why don't we read it this way? Why don't we read it in this form? Why don't we say this is permitted? The law doesn't say anything to the contrary. You have to remember that this operates in the Puttaswamy framework. So those fundamental principles of privacy will still continue to apply. Just wanted to add that on to what Jaideep said.
No, thanks. Excellent. Arun, maybe you can elaborate a little bit, help us understand what are the features and highlights of this bill.
Yeah, so look, it's a big step up from where we are today, right? Like Jaideep said very correctly, this is a strongly consent-based regime. Much more so than GDPR, much more so than any, I mean, the CCPA has some common elements to it, but it is one of the most strongly consent-centric regimes in the world. The only basis for most private entities to process data under this law is free, fair, informed consent. Now, those of you who operate in the GDPR will immediately prick up your ears because that phrase has meaning and it's taken a lot of meaning under the GDPR. It means that your notices have to be of a certain standard. It means your purposes have to be called out. It means that you have to bring it out in a way that is very transparent and evident to somebody who's reading it. If you don't do that, your consent is not valid. And if your consent is not valid, your processing is not valid, and you won't find this out on the day you put out your notice. Nobody is going to write to you and say, hey, your notice is vague or opaque. You're going to find out when someone drags you to the data protection board saying you're not processing with consent. The second piece, which is very important and a big step up from the current law, is look, today law only really protects sensitive personal data. The Indian law is unique in the fact that it makes no distinction on the various categories of data that are there. Whether it is your name, or it is your cancer diagnosis, it is protected at the same level under this law. All is personal data, all of it is protected. All of it needs valid informed consent. The burden of proving consent is on you. The burden of proving consent is not on the user who has to come back and say, hey, you don't have my consent. You have to demonstrate that there is a consent. There's a new regulator in town. Again, unique about the Indian law, this regulator has no rule-making powers. All this regulator can do is enforce. The rule-making is still with MeitY, which is the government of India. This regulator only has the ability to enforce and pass penalties, and those penalties are huge. 250 crores is one of the penalties, but that's not the one I'm worried about. There's a penalty of 200 crores just for not notifying a breach. And this not notification of a breach, again, unique under Indian law, breaches have to be notified to every individual affected. Everywhere else in the civilized world, if there's a breach, you can go to your regulator and say, look, yes, there's been a breach. I don't feel it's useful to go tell everybody that their email address has been breached. I don't need to go and do this. Indian law, you have to go and tell every single user. So basically, whatever is private is now public. Lastly, and perhaps most importantly, as a strong step up, right? Under Indian law, till today, we are all spoilt with a collection-based regime. All obligations are on the collector of data. So if you have say a payroll vendor or a provider who's just, doing HR services or whatever, that entity is responsible because they are collecting the data, so they have to comply with the law. Under this new law, the entity that determines what happens to the data is deemed to be a data fiduciary. It doesn't matter what your underlying relationship says, it doesn't matter who's doing the collection, it doesn't matter, all of those things don't matter. If you determine what happens to the data, if you determine the purpose of processing and the means of processing, you are responsible under the statute, not only for your own actions, but also for the actions of the entity you hire to process this data. So if you hire a payroll processor and they breach the data protection board is not going to come to the payroll processor, they're going to come to you. And in spaces like, for instance, insurance, right? Where you have a massive number of insurance agents, you have e-commerce platforms which provide it, or for that matter, we're talking about lending, where you have a bunch of people who originate loans, process loans, do recovery work for you. You're talking about a situation where you have retail, right? People who are providing logistics services, or healthcare, for instance, where you have a bunch of doctors. In all of these situations, these controller-processor distinctions become very important, and all of them have to be documented contractually, and you have to make sure you have the ability to pass through these significant penalties in your contracts. So it's a whole new world, both in terms of liability and in terms of how businesses think about data. At the risk of being a little bit provocative, our approach to data in India till now has always been more data is good, more processing is better. Right? The answer to whether you want some more data is always yes, please. I think this law will change that. I think, and of course the regulated sector has already seen this to some extent thanks to the Reserve Bank of India, but at some point Indian businesses is going to have to rethink their relationship with data, especially personal data.
So GDPR is probably one of the most famous personal data protection regimes in the world. from what I understand, it does differ quite a bit structurally, right? Because GDPR even relates to offline data, whereas ours is purely digital. Maybe you can explain a little bit how it actually differs.
Yeah, so I mean, look, the distinction you make is important optically, but perhaps less so as time progresses, because I think data which is just kept completely offline, I think is eventually going to become somewhat de
Digitized
minimis,
somehow,
right? I don't think any significant volume of data, except maybe in government, happens offline these days. But I think one of the fundamental conceptual differences I see from the GDPR, and I picked up some of them in my earlier point, is really the focus on consent. In GDPR, consent is an exception. Most processing under the GDPR happens on the basis of contract or legitimate interest of the data processor, so or the data controller, right? In India, there is no data controller. In India, there is a data fiduciary. Now, again, two of the folks on this table will understand that's a very important distinction. When you're a fiduciary, you hold data on behalf of someone in trust. You're not controlling the data, it's not your data. So it's a fundamental change in the mindset of how it will be interpreted. Second, there's this dedicated regulator whose only job is to hand down fines. Remember that the compensatory regime is not existent under Indian law. Under GDPR, there may be compensation which comes out and so on. Under Indian law, it is a penalty, it is a fine. It goes into the consolidated fund of India. So that 250 crores which may get imposed may pay for a new office building. It's not going to pay your data subjects in question. Third, I think it's a very distinct regulatory environment. Europe started with the Data Protection Directive, right, which came out 2013, 2012. Since then, they had an Article 29 working party which put out, I think, 1500 pages of guidance. Then they had a law which came out, and then there was a clear 2-year period for implementation. Billions of dollars were spent on that implementation. Law firms, I know, some law firms doubled in size just to address that need and prepare people for the launch of the GDPR. And they had two very important bases to process, which is contract and legitimate purpose, right? Despite all these things, the majority of Europe was not compliant with the GDPR on the day it came into force. Now you're looking at an economy in India where the rules are being drafted right now. We are expecting rules to come out in a few months. There's a general election coming in April. I'd be very, very surprised if at least some part of this law is not in force in some form by then, just because it's an important tool, right? Now, in that framework, if you're talking about such a raw economy with such a huge step up, so little preparation, being told to take up such a massive burden, I see a very distinct evolution for this in India.
Thanks a lot for that. Satish, maybe you can jump in now. You're the CISO of Kreditbee. What is this? What's going to be the impact for BFSI and MSMEs in India?
Oh, okay. Thanks for having. And so basically, the impact is going to be quite significant. While no doubt the whole BFSI and the fintech are already have a lot of regulations coming from RBI. Of course, I'll talk more in the data protection context, while my friends have covered the legal aspects. And so definitely there are a lot of significant changes, as Arun spoke about consent, taking consent, and also I think those changes has to be done by these, especially the fintechs and the financial players. Especially go back to the product, as if you look at while fundamentally we understood about security by design, right? The privacy by design, like you have to go back and ensure that all those provisions are in fact incorporated into the larger framework, how the personal data is collected, consent management, and of course even the whole, once that purpose of the whole data processing is over, now how do we ensure that I think I'm talking about the overall data life cycle. In fact, that's one of the biggest challenge, in fact, which while as a compliance, of course, especially banks are anyway have a lot of stringent compliances coming from RBI. Cyber security framework itself has a lot of provisions on incident reporting, all that. That framework already exists. But typically, personal data protection, those controls, additional controls, especially data protection, encryption, key management, data retention, data localization. So all those has to fit into the larger framework, which is one of the biggest concern for all these fintechs and banks who are collecting, processing a lot of personal data. So data protection is going to be one of the biggest challenge, and of course, so a lot of organizations are preparing that ground, including making changes in the product itself. You know, especially the product itself may not have an ability to take consent. In fact, that has to you have to go back and change. Especially all these wallets and a lot of these fintechs, they have to go back and make a lot of changes in the product itself.
Yeah, no, like Arun said, consent seems to be a very big issue.
Absolutely, yes.
And from what I understand, if a user wants to withdraw consent,
Yes.
then you have to somehow find a way to delete their data.
So
as
those
well.
provisions has to be incorporated, and it has to go back to the product.
Exactly. You will have to create some method to find that data and then only delete that, which I'm sure is not an easy task, especially for smaller companies.
Yes, that's a big burden, in fact, and it takes a lot of time also.
So Thomas, why don't we come to you? SocGen, one of, I think it's the third biggest bank in France, from what I understand, one of the largest in the world. Large MNC like that, obviously they generate, consume, utilize massive amounts of personal sensitive information, right? So what are you seeing? What's the impact going to be of DPDP for SocGen?
So I'll talk more from a data office perspective, right? So SocGen as a bank, as a French organization, have been used to, working with GDPR. I mean, one of the implementers of GDPR. So what happens when personal data comes to India, right? For EU citizens, that's kind of the same approach that, or a similar approach, what we are going to take for DPDA, right? And the scope here is not Indian citizens in India alone. It is Indian citizens anywhere in the world. Indian customer data which goes anywhere goes as well. So as from a data office perspective, or as a data officer, one of the biggest concerns that I would have is to find out which all countries, which all processes this data is going to, right? So a clear process map is needed, because I know how difficult it was to create a process map which houses PII information, or personally identifiable information, when we were getting processes done in Paris, right? And then going to Romania or India for that matter. It was such a difficult job. Now think of Indian processes going, or data getting transferred across the border, and employees who are working outside of India, how do we protect their data? So it involves getting, one, identifying the process which has the data. Second is doing the privacy impact assessment, right? I mean, what happens to these processes? Does it contain sensitive data? Is it identifiable to an individual? Or is it something that is on the periphery? That is something that needs to be assessed. How critical is it? But now that's a big concern, considering what I heard right now, saying that even if it is not sensitive data but gets leaked, it's going to be a problem, right? So that's one element on the privacy assessment. Second is the third is the obligation to store the data. So in GDPR, there is always this consent, where a person can say, okay, take my data. Then he can, or he or she can actually say at a later point in time, forget my data, right? And then we are supposed to forget it. Or, hold it for some time, not processing it, that's all. They can withdraw consent, or they can reject consent. So in that case, as a system, as a process, we should be in a position to actually identify and immediately pseudonymize, purge, or anonymize the data. But that kind of mechanism is not there for India right now. The data, especially our employee data, is unfortunately in many cases, many organizations, it's in Excel sheets, which is a big challenge. And then, as he said, right, if I am giving it to a payroll system or a third-party processing, now I send it to my offshore center in, as I said, Bucharest or Poland, what basically happens is I need to make sure that they hold their, they sign their data protection agreements, right? That I have, right? And they need to report if there is a breach. And hence I need to control their mechanism as well on how they handle the data. That is also, it becomes a very important factor for as an MNC. So in all, it's easy to say, oh, you know what, DPDA is similar to GDPR, but when it comes to an implementation angle towards the Data Protection Act in India, it is a very cumbersome and a complicated process.
Satya, why don't we come to you? Aditya, Birla Group, huge corporate. We've looked at how MNC, the challenge they'll have. We've touched on MSMEs. We'll get to SMEs a little later. But right now, for large corporates in India, what does it look like? It's going to be obviously a huge impact, right?
Yep. So I'll come to the conglomerate kind of Aditya Birla Group and being in a central function on a data analytics side that I'm part of that. So there are multiple different kind of hierarchies, right? So there is a central CISO body who enforce the laws from the government of India or any kind of a security best practices. There are each of the CISO body for each of the businesses. I think the coordination between them of implementing any kind of a law in practice, probably in any kind of a real time, that is a bit challenging because the central CISO won't be responsible of any kind of a data loss where that has to be responsible by the business CISO, and how that need to be enforced towards each of the businesses. I think that is the challenging job. Where it is coming from as an experience from our side, because we act more like a data fiduciary, what Arun just explained, and the role became so critical in this kind of a DPDP launch also from the government, how it happened, because we come in between of the data processor, though it is a market vendor, versus the data owner, which is actually business. So we decide, being as a AI, the function that what to be done with the data and how much of the data that we need, because before a decade, there was a statement that the data is a new oil and we don't have a data, but currently that statement has gone away. So we have a lot of data, but how to govern the data in a right way, I think that is the question that everybody has to act on, and that is also this law is enforcing to us. So there are a lot of assessment is going on after this kind of enforcement happened from the government, where we were doing a Hawkeye assessment to all the kind of a business CISO as well as the corporate body like us to see that what kind of a data we really hold. Is it a PI information? Because there is a learnings as well as a probably a training also needed from this lot of corporate people, because though it is a manufacturing guy, he won't be knowing that what kind of a data do I hold? Is it a machinery data or is it a PI data? But if let's say I'm building out a logistic platform also, whatever you just explained, Arun, and if a driver has a Aadhaar ID and that is linking to his bank ID information in the going future, I think that will be a very sensitive information. So all those kind of assessment is going on currently inside the group by the central CISO team, as well as each of the functions like us also, who act as a advisory body to each of the businesses. And from the assessment, the result that we will be getting out of that, probably some kind of a practices that we need to follow, because currently the security by design, which is coming to a architectural standard which was not there earlier, but this kind of a law also enforces that any kind of a data architecture or probably the cloud architecture that we need to build, we have to make that security by design from the starting itself. Instead, a audit happens and we found something and find some kind of a vulnerability fixing. I think the other trend also, it's going on this kind of a conglomerate, and we have a lot to see also in the future.
No, that's interesting. Please. Thomas, take it.
That's a very important point. I think that's a very important point which we are facing as well, right? Is the fact that access to data takes a lot of time. So we have the data protection board on one side saying I need reports, almost immediately, real time, all those things. And on the other side, we are governed by the data protection board, which says you need to make sure that the PII data does not go out of your organization, or let alone within the organization, people who are not supposed to have access to it will not have access to it. So any data that we give access to people need to go through, legal, compliance, IP related, all those elements before it can actually, convert into reports or analytics or something like that. So these kind of laws, actually what happens is, the value that you generate from data, also the time to value gets affected with this, until and unless you have the privacy by design concept already in place.
No, Satya, coming back to you, just like what Thomas said, from what I understand now, it looks like you'll need a lot of different tools, systems, processes just to take care of all of this, right? What does it look like at your end from a techie's perspective?
Yeah, I think there are a lot of practices, let's say, on the cloud, because we have a central team who takes care of all the cloud design and the implementation for all the different group businesses. I think a lot of practices and the standard is getting enforced by them. Let's say I am giving access to any of the data processor guy and he is doing some kind of operation on my cloud environment. So what kind of a monitoring that I'm doing? Do I have a monitoring tool in the picture to monitor it, that key, what kind of a data that he's playing with? Is it he's downloading some kind of data in his systems, or it is more from the cloud platform that he's operating? I think a lot of those tools and technologies come into the picture. There are a lot by the OEM, it is available more from the AI trends, but I think there are still a lot of things need to be explored and see that key. Am I making a roadblock to the whole project delivery by enforcing this kind of a secure design? Because the intent of all this law is that I need to make my design secure, but on the other side also I need to make sure that my delivery should be efficient enough of giving the results. So between these two pillars, I think there are a lot of debate is happening, and also I am deeply involved with my cloud central team of discussing those kind of a platform and see that what kind of efficiency blocker it is and what kind of efficiency it is supporting me. But I think those are still in the exploratory stage of getting implemented, this kind of a principles.
Okay, excellent. So, Satish, why don't we get to you? Now, these data protection regulations, they're complex, but they're very necessary, right? So now large corporates obviously have so much financial strength. What about all these smaller companies, especially for a country like India, where I don't know what the number is. I think it's some staggering 90% of companies are MSMEs from what I understand. So what happens to them?
So you mean to say the cost
in
of
terms of
compliance?
cost, like
Cost of
how do you
compliance.
implement such complex?
Agree. So as you said, while large enterprise will have teams and structures in place, but of course, compliance, there's no exception for compliance, right? You have to be compliant. So hence I see a lot of tech startups or tech companies, MSMEs, they will in fact fall back on automation tools. That's the only way how we can really achieve this compliance. So there are a lot of today compliance automation tools which will help you to in fact automate your complete data lifecycle management, compliance. In fact, there are a lot of privacy compliance tools which will help these kind of MSMEs, startups, because typically startups are tech companies who write their own code. They are fine to automate, as I said, especially in the cloud. Most of the digital natives, I had experience to work in digital native. They do a lot of automation. Compliance automation is the key, and that's the only way how to stay compliant, rather than believing in large teams. Of course, there's no luxury of large teams in these tech companies. But a lot of tools today, in fact, compliance automation tools will aid them to be compliant.
Please, jump in.
I want to take the rare opportunity to actually share good news on this, right? Which is one of the provisions, and we've been engaged in terms of, and Jaideep's firm has been as well. This has been a responsive government. They've listened, they've taken consultations, they've taken industry feedback. And one of the things that's happened in the last iteration is that there may be potentially some additional time given to SMEs for compliance. So they might actually have a longer period. The big platforms will obviously be impacted immediately almost, and large conglomerates may be close to that. But SMEs may actually get a little more time. So
I think
rare piece of good
similar
news.
to certain guidelines.
Yeah.
Certain also gave some time for
6 months there.
MSMEs.
So hopefully we'll see a little more time for the smaller enterprises.
I know we just finished an entire panel on Gen AI, but I feel like we're begging the question, since Satish mentioned automation as well. That might be the only thing that will save all of these smaller companies. Maybe both Arun and Jaideep can just jump in. What do you think? Gen AI is going to help smaller companies in being compliant with DPDP?
Potentially for some kind of intensive combing of CSVs, etc., to maybe weed out aberrations. That's the immediate thing that I can think of which comes to mind. But then, of course, mistakes that the Gen AI makes which human being is going to pick that up is the question.
I see Gen AI and privacy as both a demand side and a supply side issue. So a lot of people in the SME space especially are reliant on Gen AI just because what they do would not be possible at their headcount without strong automation and AI enablement. Now, the great news about this law is that there is a huge exception for public data. So basically, if data is either made public by the person or is public by action of law, so things like your, RBI defaulters list, things like, anything else that's published on a government portal because of a legal reason, that is excluded in entirety from this law. So if you're a startup, you're reliant on Gen AI, you want to feed information into Gen AI for the purposes of processing, as long as that's public information and it's been made public under one of these two headings, you have the ability to continue using Gen AI. So that's one thing. It doesn't like shut the shop to that extent. On the supply side, fully aligned with what Jaideep said, it can be used to automate certain kinds of tasks. But if you were to say, ChatGPT, write me a privacy policy, I mean, it might. It's always, I always hesitate to say that it may not do a very good job because you have to ask and check. We've tried. Look, one of the things where it's very valuable is in terms of simplifying concepts, right? And just explaining things in a very simplified way. So if I were a startup founder doing something which was very unique, very different about data, I need to find a way to explain it to human beings in a very simplistic way. That might be another way in which Gen AI is usable because, one of the most useful commands I found on ChatGPT is, hey, ChatGPT, simplify this paragraph.
Trust me, as a journalist, we find that also extremely useful.
But there is one more thing about Gen AI. There are quite a lot of implementations of on-prem models now where the information does not go outside. I mean, that's where the lot of enterprise implementations are happening right now because it's not only personally identifiable data, sensitive data, secret data, all those things are not supposed to go out. And there is quite a lot of implementations of ChatGPT, not ChatGPT, at least the Stanford APIs in an on-prem mechanism so that the data does not go out. So those can actually help.
I think I can just share the same kind of examples what we are trying in live on that piece because so initially we built a POC where we can identify that key for all the manufacturing sectors, what are the top 3 different kind of incident on the safety or the sustainability side, right? So then we had some kind of a conversation with the business and that went through also based on what the value the Gen AI brought into picture. But then the next challenge comes, can I train these models on top of my data onto my system? Because even it is a planned sustainability data for a, let's say though it is a Hindalco business or a Ultratech, they are not more comfortable or it is a kind of a violation if that can go to a public and kind of a incident, all these things can happen, right? And there we started discussing with the Microsoft team also, can we build out this OpenAI model, train into the own kind of a on-prem systems and build my own prediction key from my last year of the number of incidents happen, what is the top 3 different kind of incident and how I can mitigate the issue. I think this is a current phase where the whole GNA is going on because as a vibe it looks very good to give me something publicly, but as a real practical need it will definitely come to my private set of data onto my private systems, how the cloud is working or how the on-prem kind of a model is working. I think it is still progressing in that stage, but I think it will come one day where I can train all the data into my own model itself, which won't go in a public kind of a sectors, I think.
Lots of startups are also coming up in this space. So the innovation in the next few years could be something to look out for. So Satya, coming back to you, let's touch on the data governance framework. This supports the implementation of policies, rules, and data-related procedures. How do organizations manage internal and external data governance? That is government specified. I'm talking about policies and how data is gathered, stored, processed, disposed of. Maybe you can touch on that.
Yep. So I'll share a few of the examples on this kind of a conglomerate scenarios, how we generally take care of this kind of a data processing and both the internal and the external data. So we have a lot of different partners, the vendors who do the development on the ecosystems. It is from the business side, it is from the corporate side, and a lot more kind of a thing, right? So there is one of the initiatives got initiated from the central CISO body where we do the assessment for each of the vendors and what kind of data they hold, because there are some kind of a scoring has to be done for each of the vendors, and based on the scoring, probably who are the top two peoples who are holding the actual PI data on any kind of a project, we need to assess their systems, their peoples, and all those kind of practices also they follow. I think that is the one of the practices on the data governance framework which is coming into live that I can see over here. More from the tools and technologies and the data purge and those kind of a policies, I think data localization is coming as a one more angle which is coming to multiple different kind of businesses, because our businesses are present in lot more kind of regions over the globe. So how it can localize my data based on its policies, though it is a Euro factory or probably a Canada factory and those more kind of a different companies, I think those are coming into the place of the principles by design that we need to align it. And lot more kind of AI tools also is helping out. One of them is the Gen AI, but lot more different kind of a cloud or the AI tools is helping on that manner itself.
Thomas, you want to jump in?
Yeah, so especially on, so I'll quote an example, not relating to personal data. So we have these Bloomberg licenses, right, which gives real-time prices of, shares and stuff like that to see whether. So in our organization, what used to happen was anybody would go and procure a Bloomberg license. And those are not cheap licenses. Those are humongous or very expensive licenses. Now, what has happened because of this data governance and the fear of leakage of data is one thing, and wanting to know what all data you are getting and transferring outside, there is some amount of data governance which has led to consolidation of and propagation of data as well. So in the sense you get the Bloomberg data once, you propagate it to multiple places, you take reference data from Dun & Bradstreet once, but then you propagate it outside. So there is quite a lot of consolidation that actually happens, which helps manage the data and propagate the data as well. That is one element. The second element is in your data governance or the data definition, when you have the business data defined, you clearly articulate now whether it is a PII data, is it a secret data, is it a sensitive data? I mean, we have categorization, different kinds of categorization of data, which leads to different kinds of treatments of data depending on the sensitivity. So these are the things that has actually helped, with these rules, the data governance element.
Okay, excellent. So this is basically the last question. Arun, why don't we start with you? What steps should be taken by organizations now practically to comply with the Act? What does that look like? What does the journey look like, in the next 3 months, 6 months, 12 months?
Yeah, I'll answer the last part of your question first, right? Because right now nobody knows if it's 3 months, 6 months, 12 months, 18 months. We all hope and pray it's the last one. But like I said, there's a general election coming. I'd be very surprised if at least some part of this, at least for the large platforms, is not enforced before that. There's obviously still a little bit of ambiguity, right, in terms of what's going to come out in the rules. And the rules will cover important things like notice, consent, sharing, etc. Now, I think it's kind of interesting that we heard this from 4 different sources on this table. The first step that any organization should be doing right now is mapping. Right? You need to know what data you hold. You need to know why you hold it. You need to know what you do with it and what purposes you use it for. Just fundamentally, if you're not aware of these things, you cannot comply with this law no matter what the rules say, because at the core of it is that you need to get consent for a specific purpose. Right? There are 2 unique things about this law which are different from anywhere else in the world. Even if you take valid consent for a purpose and you record that consent in every way, if that purpose is not necessary, that consent is not valid. Even if you have an internal policy that says you have to retain it for a period of 5 years after you collect it, the government is going to put out rules on the basis which you have to delete it, right? So like we heard multiple times on the table or the stage, this means that you need to be able to horizontally identify a piece of data across your organization and provide for things like erasure, correction, de-identification, whatever it is, you need to be able to do that in a horizontal manner. And to do that, you basically need a data map. From this data map, you may be able to determine some of this data is irrelevant. I don't need to hold it. It was great to get it when we could, but right now it's just too expensive to store. I don't need it. For some things, you may say, look, consent is not a valid basis. If you're a bank or a financial services institution, you may say, look, I cannot rely on people to continue to give me consent to process data for regulatory reasons. Right? The moment I find out that someone has defaulted on a loan, or even if I suspect that somebody is up to no good, there is a fraud, suspected fraud, whatever it is, I need to be able to report it to my regulator on a basis other than consent. So to that extent, I might need some regulatory air cover, right? There are certain processes that you do, like if I'm looking at digital lending, I may not be processing that data in the best interests of the borrower, right? I might be processing it in the interest of the market. If out of 100 people I deny credit to 5 people who are likely to be fraudulent, my interest rates go down. To that extent, I might need regulatory air cover. So, fundamentally, I think it's mapping. Second, get a sense of where your current pose or your position is as far as these requirements are. These two actions, I think, are immediate action items. Then in terms of actually implementing the new documentation, deleting things, modifying things, changing business process, that might be a thing you want to leave for a little later once the rules are out, because that has a business impact, etc., etc. There's absolutely no reason. And the last point I want to leave on the table is, there's a unique creature under Indian law called a significant data fiduciary, right? So basically, if you hold more than a certain amount of data, or what you do with it is sufficiently special, you have an impact on the Indian ecosystem or the electoral democracy in India, whatever it is, you can be called a significant data fiduciary. And if you're a significant data fiduciary, you need a full-time data protection officer who reports to your board. You need to conduct a data protection impact assessment, audit, certification, blah, blah, blah. Those kind of entities, if you're a large, significant entity that holds a large data set, I would be looking for people right now. Because once these rules are out and once they notify a data fiduciary, the data protection officer is going to become a very expensive and a very difficult skill set to find.
Satya, do you want to touch on Aditya Birla? What's happening there right now when it comes to the DPDP? How are you preparing for it?
I think
just a short answer.
Sure. I think currently the mindset of holding the PI data and to know that what kind of data do I need to hold. The region for that, I think what Arun just said, that is going to be a very critical piece after this law. I think the assessment will definitely say those kind of results, and those principles will come where nobody will just hold any sort of the data for their own project. They should be having a proper justification, proper lifetime that they will need to hold this data, and what this data need to be doing for the other piece of the data processor. I think these are the angles we are looking into it at this stage.
Jaideep, do you want to jump in? Trilegal, I'm guessing you're getting a lot of calls, a lot of companies. What does it look like the next 12 months for you? Is it just helping everyone deal with this?
Yeah, I mean, just to add to what Arun said, there's also, obviously a company will ask, how do I change my current privacy policy? It's not as simple as changing a few lines, because even those few lines, what exactly you need to change is still under question, because, for instance, how long can you retain data? How do you give notice of the purposes? Those are yet to be prescribed by rules. But even beyond that, the way your consent flow is, the way your internal processes are on how you provide for erasing data, passing on data to others. Potentially, there may be blacklisted countries which get notified. You cannot transfer to those countries. So it's a holistic exercise beyond just today's exercise is very much centered on the privacy policy. This is going to be a more holistic exercise.
Thomas, quickly want to jump in? SocGen, what are they up to? Are all the Parisians very angsty about all these new laws?
Yeah, so obviously, yes, there is quite a lot of studies that are going on to try and find comparisons, similarities, differences between GDPR and EPDA. One of the most important things that I think we need to understand, at least from an India setup, is the mindset. The fact that I can take any data and process it whichever way I want, send it to whichever organization I need, that kind of mindset need to change, and all of us, mean more than SocGen as well, need to be responsible about the data that they handle. And that's my take on this.
Satish, Kreditbee, if to give out a lot of loans, what changes now when you have all these new rules?
No, I think,
what are you planning?
I think overall the whole data lifecycle management has to be worked upon, and as you said, DPIA, all of them.
Yeah. Okay, excellent. Well, thank you everyone. Thanks for everyone for listening.
A huge round of applause, ladies and gentlemen, for our panelists and our moderator here.